My name is Rachael Griffith. I'm a lawyer in Tyler, Texas. Today, I want to talk about the Texas Lawyers Creed and what I consider as ethical advocacy. In Texas, the Supreme Court of Texas set out the Texas Lawyers Creed a number of years ago, which is a mandate for the professionalism that lawyers are called to. Your lawyer should be providing you a copy of the Texas Lawyers Creed or directing you to a place where you can access it whenever you retain them. We are supposed to inform all of our clients about the Texas Lawyers Creed and that we're called to abide by its commands. So there are certain parts of the Texas Lawyer Creed that relate to how a lawyer is supposed to relate to a client, how lawyers are supposed to relate to other lawyers and the court. And it all sort of sums up the ethical obligations that we have towards the legal system, the legal process, so that we can keep ethics as a main focus of our representation. We do not abide by these commands, these creeds, then we can be held sanctioned by the court, either sua sponte, on the court's own desire, or by request of other parties, because we are doing things that are unethical. Some of the things that lawyers are called to do by the Texas Lawyers Creed are things like endeavoring to achieve our clients' legal objectives. So we're not supposed to be doing anything that's unlawful on behalf of a client. We are expected to act in a way that is civil and that gives professional courtesies and inform our clients that those types of things are not a sign of weakness, but are a sign of an ethical advocate. We are called to treat adverse parties and witnesses with fairness and due consideration. We are called to not pursue conduct that's intended to harass someone or drain their finances. We're not supposed to purposefully do those things. Some of the things that we inevitably have to go through are a hassle to go through and are expensive, but we're not supposed to solely file things just to harass someone or to be a financial burden on them. We are called to pursue tactics that are intended to take consideration for others, not intentionally cause delay. So just because we can do something in a case doesn't mean we should. If it's unnecessary strategy for the case at hand, but somebody's trying to be sneaky and do it just to delay or cause other person harassment or cause the other person grief, then it's not necessary for the case. We're called to advise our clients of that and avoid those actions. We are called to engage in good faith negotiations. So it's a waste of everyone's time if we send settlement offers or avoid responding to settlement offers just to have a bad faith interaction with the other side. We need to try to settle things and be respectful of the court's time, of opposing counsel's time, and of all the client's time. We are called to give common courtesies for other attorneys. So an example is if I know a case is scheduled for a hearing and the other attorney has told me, hey, I'm having surgery that day or the day before, can you agree to move this case? And I know my client is really going to hate it. It's going to be hard for them because they've spent time and effort preparing for the hearing on that particular day, but that it's a common courtesy to allow a continuance for an important medical need, then I need to go ahead and tell that other attorney without checking with my client that yes, I'll agree to the continuance. When can we do it? It's sort of a golden rule situation. Whatever you would want for you, you'd need to freely give to the other side. There is an expectation that attorneys should not file baseless motions as a part of this lawyer's creed. So if somebody comes to me and in their heart of hearts they really want to file something just because, but I know after reviewing the law and the facts that it's pretty baseless, there are no grounds in Texas Family Code for me to file what they're wanting me to file, or there's really no law that's going to allow my client to get what they're wanting to get. That's a baseless motion. It's my job to tell my client, hey, I know you're wanting this. There is no law that I know of that can get you to that result, and it would be baseless for me to file this, and we could be sanctioned, both the client and the attorney, for filing a baseless motion. It's my job as an attorney to tell the client that, even though it's pretty hard to hear. There are some things as a part of a case that an attorney decides and not the client. Things like whether or not to settle, that's the client's decision. At the end of the day, I can't force a client to settle something, and neither can a mediator. But whether or not to pursue certain motions with the court, whether or not to grant extensions on discovery, things like that, that's an attorney decision. And if there's ever a point where you're butting heads with your attorney and you want to pursue something, but the attorney's telling you no, or vice versa, they want to pursue something and you don't think it's appropriate for your case, you may be at a point with your attorney where you are not able to have effective communication, and that attorney-client relationship needs to end. You can do so by consent. You can sign a motion for withdrawal and agree to that motion for withdrawal, and that attorney can get off of your case. Or you can go hire a new attorney, somebody you're more aligned with, that can file in and substitute for the original attorney. So it's important to talk about strategy and the why of strategy in your case and make sure you and your attorney are on the same page. The Texas Lawyers Creed also directs lawyers on how to engage with other lawyers. We are not supposed to quarrel over matters of form or style. We're not supposed to withhold information that we rightfully have to disclose. We can disagree with opposing counsel without being disagreeable. We're supposed to engage in a way that promotes civility and professionalism. Things can get heated when you are on opposite sides of a case. It's okay to have a good faith and disagreement, but when it crosses over the line of disrespectful or sanctionable or in bad faith or argumentative, that's when we need to sort of have a gut check with ourselves and say, hey, we need to get back on the line of civility. Your attorney should be acting in that way to ethically advocate for you. We need to do that same thing in court. It's important for us to be civil in court with the judge, even if we dislike the judge's ruling on objections, the judge's ruling on the case. We need to be civil and respectful and have a certain level of decorum in the courtroom. I talk about all of these things to help point out to clients, to maybe new lawyers, that just because you are hired to fight for a case doesn't mean you have to cross over the line of no longer being civil or professional. In fact, the Texas Supreme Court mandates that lawyers act with professionalism and civility in the state of Texas. When you hire an attorney, this is something you really need to look at. How do they conduct themselves? What is their reputation? How are they strategizing your case? Does this feel ethical and above board? Are they on the same page with you? These are all heavy considerations because it will really deeply affect the course of your case and the results that you end up getting at the end of the day. So make sure, and if you feel like you're not comfortable with the lawyer, you have a consult with another. It's okay to consult with more than one lawyer on your case and really pick the person that's right for you.